Good evening, you're watching the Urban Debate on Mirror Now. I'm Faye D'Souza. Thank you for joining us and a very happy new year to you. Getting straight to it, the government has tabled an Aadhaar amendment bill in Lok Sabha today. Now, the reason why this bill is important is because several members of the opposition say this bill will actually cut across what the Supreme Court told us in the Aadhaar judgment when it said that private companies should not be allowed access to Aadhaar data. Private companies should not be allowed to use Aadhaar for verification of identity. And they shouldn't be allowed to store data, apart from several other things. The government has reiterated on its part that this is in line with the Supreme Court judgment and it does not violate any of the decisions made by the Supreme Court. Joining me on the show right now, Shashi Tharoor, Member of Parliament, one of the clear voices today that raised objections to the bill. Mr. Tharoor, good evening to you and Happy New Year to begin with. An interesting start to the new year in Lok Sabha. Would you be able to explain?
Happy New Year, Faye.
Would you be able to explain to our audience, please, what your main objections are to the amendment to the Aadhaar bill?
Well, I have three major objections. The first of which is exactly what you were saying in your introductory remarks, which is the real problem I have with the clash between this bill and what the Supreme Court has decreed in the Justice Puttaswamy case, the sort of Aadhaar case. Because what the bill that the government has put forward today enables it to do is it allows the government to enact laws to provide for mandatory Aadhaar-based authentication for the provision of quote-unquote any service. That's clause 5 of this bill. Now, what does any service mean? Who provides any service? It could clearly include private services and private companies. The law would actually permit that. So the bill then is allowing you to do something which the Supreme Court has explicitly said the government should not do, that is to allow private providers access to your data. That's number one. The second one is a bigger issue, which I think as a policy person, you would appreciate the logic of my taking the stand. And I believe I was the only one who did that, but I feel it very strongly, that you first need to have a data protection law adopted before you can go around amending Aadhaar. The government has promised us a data protection law. They put Justice Sri Krishna to work. He came up with a draft. I myself have submitted a draft both to the minister and indeed table one as a private member's bill. There are ideas out there. Let's enact a data protection law that actually protects the data of every individual Indian citizen. And once you've done that, then you can see how to bring your Aadhaar bill in conformity with that. To adopt this amendment in the absence of a data protection law is actually mischievous on the part of the government. My third objection is somewhat simpler. The bill completely blurs the distinction between identification and authentication. Aadhaar is meant to help you authenticate. It's not an identification document like a passport. A passport is an identification document. Aadhaar is an authentication service or number. And that distinction ought to have been made clear rather than being blurred by using the two terms interchangeably and synonymously in the bill. But these are the three main objections, of which arguably the one about the privacy law is the most fundamental in terms of substance. The one about the data protection law is the most fundamental in terms of process. And then finally, the last one is about writing or language.
Well, Mr. Tharoor, the amendment actually uses the word voluntarily in Section 5 that you're talking about. It says every Aadhaar number holder to establish his identity may voluntarily use his Aadhaar number in physical or electronic form. Now, the government may argue, although they haven't done so today, that the use or the inclusion of the word voluntary then basically leaves it to the citizen and thereby respects his privacy.
No, let me read the offending part of Clause 5. It says, notwithstanding anything contained in the foregoing provisions, mandatory authentication of an Aadhaar number holder for the provision of any service shall take place if such authentication is required by a law made by Parliament. So, in other words, the provision of any service could include your private phone company deciding that it needs this authentication. It could include a private service provider, a private retailer, a private social media provider, who knows who. all sorts of people could require your data, and this law would actually cover them while they did that. Now, if this is not the intention of the government, as the minister somewhat disingenuously claimed, then he should change this language. Because the language seems to me, and I've had a lawyer read it, seems to me to actually permit exactly what the court said it should not permit.
Well, it also, if I may just read the entire amendment of Section 4, the one that you're referring to that you say is the offending bit of the amendment. It says the entity may be allowed to perform authentication after the authority is, by authority we mean the UIDAI, is satisfied that the entity is compliant with standards of privacy and security, that the entity is permitted to offer authentication and is seeking authentication based on central government's identification of interest of state. So leaving it finally in the hands of Parliament, as all laws are left in the hands of Parliament.
That's the problem. So
yes. Yes, please go ahead.
Now, all laws are left to the hands of Parliament, Faye, but my point is, for example, in the Data Protection Bill, I've made it very clear that your data belongs to you, the Indian citizen. And therefore, it's not for the authority, quote unquote, to be satisfied that your data is being entrusted to a reliable provider. It's for you to decide whether you wanted to do it or not. But if they create a situation where you can't avail of an essential service, like a telephone or a Facebook site or whatever it is, without supplying that information, then you're in a bind. And I don't think the law should allow that. My entire point is, in a proper data protection law, data will be owned by the citizen, not by the state, not by UIDAI or the authority or the government or anybody else. It'll be owned by you. And you alone should have the right to actually decide who gets to have it, for what purposes, for how long, and that should be a right you can revoke at any time. Now, if that principle that I've advocated in my draft data protection bill is followed, then you can write an Aadhaar law that says, subject to the provisions of the data protection bill, it may be used such and such, and I wouldn't have a problem. But since we don't have a data protection bill, and in any case, the one the government is likely to put forward will probably not enshrine the principle that your data is your own, then we have a problem with this law will actually contribute to creating a big brother state in our country, and I think we really ought to resist that. Quite apart from the fact that there may be commercial exploitation as well of your data by a private provider, why should we allow the state or an authority, quote unquote, of the state to decide that a particular private provider is safe and to be trusted? We all have questions in our minds about some of the close relationships between the present government and certain private companies. Are we going to encourage a sort of symbiosis between them where they will be sort of feeding each other with one with data that belongs to you and the other in return with campaign contributions? I think the mistrust that many of us feel, which this government has actually caused in our minds, is enough to give us plenty of reason to be cautious about enabling language like this.
Well, the clause 6 before the section you read out also says very clearly that the requesting entity, which would be the private entity actually asking for your data, to whom authentication request has been made by an Aadhaar number, shall inform the Aadhaar holder of it and shall not deny any service to him for refusing to be unable to, or to undergo authentication. So it also then perhaps leaves out the possibility that you may be denied a telephone or a connection of any sort or a bank account because you were unable to, or you did not want to, because it uses the word refuse, because you did not want to share your Aadhaar data. So the question then of it being mandatory, and I will concede this, it's contradictory and it's confusing. So I suppose the lawyers will have to actually figure out what this means, because these are two clauses right next to each other. You read out number 7, I just read out number 6.
No, it's actually, no, but it's even worse than what I said, because in fact I was referring to this law, but clause 5, the language that I was troubled by actually says if such authentication is required by a law made by Parliament. So you could have a totally separate law that says no one shall have a SIM card in this country unless their identity has been verified. That becomes a law made by Parliament, and under the provisions of that law, this clause would apply, and your ability to say no to your telephone provider suddenly disappears. So you see, the way
but Mr. Tharoor, are you doubting Parliament's ability?
More such intrusions into your freedom.
Would that doubt Parliament's ability to put the Indian citizens'
I'm not doubting
interests
Parliament
first?
at all. I'm doubting the good intentions of the executive. I am saying that many of us in Parliament want to put the Indian citizens' interests first, but laws are drafted by governments and particularly by government bureaucracies, and they very often are laws unto themselves, I'm afraid. So when you have something saying, notwithstanding anything contained in the foregoing provisions, that a mandatory authentication can take place of any service if such authentication is required by a law made by Parliament, all my hackles rise, all my alarm bells go off. And it seems to me you don't want that kind of language, because even if you have a great amount of touching faith in the good sense and good intentions of the present Parliament, and I'm grateful as a member of it, you cannot be sure that a future government or a future Parliament might not, in effect, create conditions that could be misused against you and the interests of you as a private citizen of India. So let's not create laws that are liable or are easy to be misused.
Well, Mr. Tharoor, the Minister of Law, Mr. Ravi Shankar Prasad, has clarified today. He said, and I quote, "Let me clarify at the onset, the proposed amendment is done in compliance with the Supreme Court judgment. Linking is not mandatory at all." He says that the government will table a data protection bill very soon. And he also said, let's not forget, Aadhaar has led to a saving of 90,000 crore rupees for the government of India. Are you not satisfied with these, with the rebuttal he has offered?
No, I'm quite happy with many good things about Aadhaar, particularly its role in direct transfer of benefits to needy beneficiaries, people living below the poverty line and so on, who need government aid and who will be able to receive it directly thanks to Aadhaar. And indeed, if that in the process enables the government to plug leakage or middlemen or people actually getting money that they're not entitled to, so much the better. That's a great thing. But I am not so reassured by some of the other things, which is precisely what the Supreme Court said in its right to privacy judgment. In the Puttaswamy case, the Supreme Court did point out very, very serious mistakes in what the government had done to extend the mandatory application of Aadhaar to areas where it was simultaneously assuring Parliament and the Supreme Court that it was not mandatory. And the classic examples are your private bank accounts and your private mobile telephone accounts, where all of us got messages, didn't we, from our mobile phone providers saying they would interrupt the service unless we gave Aadhaar.
Right.
Now, the court has said that was wrong. And the government had given assurances that it was always going to be voluntary. Why do you want to trust the government? I'm sorry. I mean, my instinct with this government is that I don't want to listen to the assurances of the law minister if they don't correspond to the language of the law that he's presenting to me. I have read out the law, the sentence that, to my mind, raises a lot of alarm bells. If his assurance is worth the paper on which this law is written, let him remove this clause.
Mr. Tharoor, last question, and this is not about Aadhaar. I am going to talk about your home state, Kerala, where we do know that 2 women have entered the shrine of Sabarimala last night or early this morning, and protests have now broken out across the state. This comes after 24 hours after 650, 1,000 women, we understand, lined the streets of Kerala to actually protest the patriarchy. Do you believe at this point the temple, the purification of the temple, like is being argued, is actually prejudicial to women, that the protests that we are seeing today are anti-women?
No, I don't think so. The problem, Faye, is that you can frame this entire issue in different perspectives and come to different conclusions. If you frame it as an issue of equality, then you will, in fact, have only one possible answer. Of course, women are equal to men in every respect and should not be denied anything men are denied. And to that degree, if you frame it as an issue of equality, there is no debate. But you can also frame it as an issue of sanctity. And when I speak of an issue of sanctity, it goes to some very, very deeply, profoundly held faiths of lots of people, including large numbers of women. It's very interesting, for example, that just south of Trivandrum is Kanyakumari, where there's the more than 1,000-year-old Kumari Amman temple from which Kanyakumari gets its name, where men are not not allowed.
Mr.
Now, if
Tharoor.
men enter the sanctum sanctorum, men are not allowed in the sanctum sanctorum at all. They can go to the outer courtyard. Now, if the Supreme Court principle is actually applied and a man decides to assert his right to go into that temple, it destroys the sanctity of the Kumari Amman temple for millions of women devotees. The question is, if you frame issues as those of sanctity, then you realize religious practices have a different set of perspectives. And finally, just let me finish. Finally, the cynical exercise we have seen over Sabarimala, on the one hand by the government and the ruling party, the CPM, on the other hand by the BJP, which happens to be the government of the centre and is an opposition party in the state, has essentially taken a sacred shrine and reduced it to a stage of political theatre, with violence and vandalism and obstruction of women and the throwing of stones and the damaging of cars, and on the other hand, people having women having flak jackets and helmets put on their head to take them to a shrine. Other women, the ones who went last night, being escorted in burqas through a VIP entrance only used by police people, rather than as worshippers are required to do, to ascend the 18 steps.
But tell me something, Mr. Tharoor, and I just
the actual offering on the head. All of which, I'm just sorry to say, both sides are disgraceful.
Forgive me for oversimplifying the issue, perhaps bottling it down to one of the things that was said by actually one of the ministers of Kerala, E.P. Jayarajan, who said the idea of purification of the shrine after women entered it is in contempt of court, because untouchability is against the law. Now, if you could explain to me, how is this different from not allowing Dalits into a shrine and actually purifying a shrine after a Dalit enters, or purifying a temple after a Dalit enters? Doesn't this effectively make women and the idea of women impure?
You know, no, Faye, because in fact, on the question of Dalit entry, obviously, I stood from my youngest days against any such prohibition, not to mention the fact that the Constitution has outlawed it also. And I would agree with you that any such ritual would be unforgivable. Yet, there are temples in India and in Kerala today in the 21st century where if a non-Hindu is found to have entered, a purification ceremony is held. Similarly, there are temples where if, for example, an infant is unable to control his pee, for instance, a purification ceremony is held. There are various acharams, as they are called, that are followed as part of temple rituals in which purification ceremonies take place in temples if the basic tenets of the temple are considered violated. Now, you and I may disagree. I've written an op-ed in the Hindu some years ago saying, why shouldn't non-Hindus be allowed into Hindu temples? As far as I'm concerned, I'm proud of my faith. I'd like others to see it.
Still, but Mr. Tharoor, I disagree with you. Forgive me, and I know we're running out of time. I disagree with you, if I may, because non-Hindus, don't have the faith that it requires, that's required to enter the temple in the right frame of mind. You don't believe, and so you have, and for example, the Kerala Hindu Places of Worship Act, introduced by the Kerala government many years ago, doesn't cover non-Hindus, and I'm fine with that. It also doesn't cover diapers of babies that can't be controlled. But for a woman who was born a woman to be denied entry based on gender, a choice that she didn't make, is fundamentally discriminatory. And our constitution, like you said, which removed discrimination against Dalits, has also removed discrimination against women. So I still don't understand the difference.
No, I mean, well, you're the one, Faye, who said that it's because the people, the non-Hindus who go to a Hindu temple, don't go in a spirit of worship, and therefore you can understand the purification ceremony. What the Sabarimala advocates will tell you is that any woman who believes in the legend of Lord Ayyappa in Sabarimala would not wish to worship there until she had turned 50, because to worship there before turning 50 would be, if she is of reproductive age, would be of something that would actually violate the very principles of the deity she was worshipping. And therefore, the only women of reproductive age who would go to Sabarimala today would be women who in fact do not believe in the Ayyappa legend. That's the irony or the contradiction here. That if
Do
you
you believe
believed in the Ayyappa you sought to worship, you wouldn't go until you turn 50. And I have spoken to
Do you believe that,
zillions.
Mr.
Okay, I'm
Tharoor?
exaggerating. I've spoken to dozens of women. Yeah, there are dozens of women who said this to me. Hindu
And should we
women in
generalize
Kerala,
their
in my own
feelings to
constituency
all
and
women?
elsewhere, who've said to me, we will not go. I'm afraid so, because I see it around me. There have been informal public opinion surveys conducted which show over 90% rejection of the premises of the Supreme Court verdict. I still honor the Constitution and the Supreme Court's judgment, but I think it's fitting that the Supreme Court is going to hear all these objections in open court on the 22nd. They're going to listen to all of these concerns and complaints, and they can't be unaware of the very strong visceral reactions of people throughout the state. I've had calls all day from the state when I've not been in Parliament today, and I can tell you the concerns, including of many women. And by the way, there are some women who participated in the wall, yesterday's wall, who said they are not in favor of entering Sabarimala till they turn 50. They were standing up for women's rights and against patriarchy, but not to go to the temple. And they've also been quoted in some of the news reports that have come out in the Malayalam media after the successful women's wall. So it's a much more complicated issue than people realize. And I myself didn't realize it, the extent to which we were touching and transgressing the vital feelings of people, until I met and spoke to them myself in Kerala and realized the depth of sentiment and anger that had been stirred by this judgment.
All right, Mr. Tharoor, I respect your opinion. Thank you so much for spending time with us here on Mirror Now and giving us your opinion. Very valid, objections on the Aadhaar debate and the amendment bill that has been tabled in Parliament, and of course the unrest in your home state of Kerala, specifically Trivandrum, where you represent as Member of Parliament. Many thanks for your time. Shashi Tharoor, the Member of Parliament, speaking to us